Hello, everybody. I hope you are all doing well, having a nice evening. This is Jonathan Ginsberg coming to you live, as we do every Wednesday night at 8:30 Eastern. So I hope if this is the first time you're here, welcome. If it's not, welcome back. And I look forward to answering a lot of questions, as we always do. Any comments you've got, any thoughts, please post them. So let's just kind of jump right into the questions. We have somebody named Nice saying something very nice. I appreciate that very much. Blue Z, who has been here before, says that she was finally approved for SSDI. Congratulations. That's a great sign. Can you break down what happens next and explain the 5-month waiting rule? Let me start with the 5-month waiting rule. And there's a lot of misunderstanding about that. Basically, what it says is the first 5 full months, not just 5 months, 5 full months after you are found disabled, after the onset date that Social Security uses, you do not get paid. Now, again, let's unpack that a little bit. So if let's say that you allege you became disabled on March 15th, then the 5-month waiting period does not start in March, it starts in April, because partial months do not count. So April, May, June, July, August, your first payment would be in September. So if you're found disabled anytime other than the first day of the month, that's a partial month. That's why when you apply for disability, it's always wise to use the first day of the month or the last day of the prior month as your onset date, as opposed to the second or third of the month, because you'll get an extra month of benefits. And even if you're still working, you can make an argument that the last couple of days you weren't really doing anything and you want to try to get that extra month. And that can be $1,500, $2,000. It can make a lot of difference. So you always want to be aware of that. Now, the other thing you have to keep in mind about the 5-month waiting period is when you look at when you become eligible for payment. In an SSDI case, you can get paid up to 1 year prior to your application date. However, the 5 months can run anytime before that. So let's say that you say, I became disabled in March of 2023, but you applied in, let's say January of 2025, which means the earliest payment you can get is January of 24, but the 5-month waiting period runs starting in March of 23 or April of 23. So the 5-month waiting period can run before you're even eligible for payment. You use it up, and then your first payment would be literally 1 year prior to your application date. So that's pretty much how it works. It's basically you look at your onset date and you add 5 months to it. That's when you first become eligible for payment. And again, if you're applied and the onset date is more than 18 or 19 months prior to that, and you're found disabled as of your onset date, the 5 months would run before you're even eligible for payment. Therefore, you max out your dollars. And by the way, this is something that I keep in mind when I'm representing a client, is sometimes we will change our onset date to make the judge's life easier. So let's say somebody applies for benefits in 2024, and they say, well, I became disabled in 2018. Well, I could try to prove they became disabled in 2018, but it's not going to make any difference money-wise. So I might want to change that onset date to 18 or 19 months prior to their application date. That maxes out the money using the 5-month waiting period before they're eligible for payment. And the judge doesn't have to worry about showing that they were disabled back, 4, 5, 6 years ago. Of course, the date last insured is another factor that comes into play here. So you need to have your date last insured for Title II disability. It needs to be before, or that date needs to be, after you are found disabled, so you don't run into a lack of insurance. Because if you're found disabled, and the date last insured is already run after the date last insured, so I'm gonna make sure I'm saying that clear. The date last insured needs to be, needs to be in place. You need to be, found disabled before the date last insured runs. So if your date last insured is in 2023, you can't have an onset date after that date in 2023. Otherwise, there's no SSDI. So a lot of moving parts, but specifically on the 5-month waiting period, it is the first 5 months after onset. So again, the onset is the date you became disabled as far as Social Security is concerned. As far as what happens next, you've been found disabled, fully favorable, which means I assume that the onset date you used is being used. Your case will then go to the payment center for processing. They will look at it. They will look to see, in an SSDI case, is there any evidence that you've been working? So they're going to look to see, do you have any post-onset earnings that might be at substantial gainful activity level? If so, you'll have to explain that. If not, which is the situation most of the time, then the case will be processed for payment. And normally the post-approval review takes about 2 weeks. Then the payment will be maybe another week or two. So normally after your favorable decision, you will see a big check in your inbox, your bank account inbox, approximately 3 to 4 weeks after that favorable decision. If there's SSI involved, then they have to do an income and resource interview, which can add time to this process. But purely for SSDI, the main thing they're looking at is, are there post-onset earnings? And if so, are they over SGA that needs to be explained? If not, then you can look at your getting a check in about 3 weeks. So that's sort of the answer to that. So normally, assuming there's no holdups, no problems, it's going to flow fairly smoothly. I have had a couple of situations. I had a case a couple of years ago where my client was a green card holder, and there was an immigration hold, not on her, but they wanted to confirm that she had a valid green card. And that somebody got stuck on somebody's desk, and we had to go through the congressional representatives to get that straightened out. But generally speaking, it runs pretty smoothly in an SSDI case after approval. So congratulations on your approval. Lily says, I was notified I have a CE or consultative evaluation due to insufficient medical evidence. I have excellent medical documentation, maintained and updated by you in the portal. Why is SSA not using your portal? Well, realize we submit things to Social Security electronically, so they don't directly take things out of our portal. We update it. What happens sometimes is we update the records, and it has to be processed by Social Security. Now, the CE, they're typically not going to say it's because of insufficient evidence. What CEs are typically used for is to satisfy Social Security's burden to develop the records. So even if we have 10,000 pages of medical evidence, the adjudicator can still send you out for consultative evaluation. So one of their doctors can look at it. So it's not typically because of insufficient evidence. It's they want a functional evaluation from one of their doctors. It is sort of within the purview of the adjudicator to make that decision. If they decide they want to send you out for a CE, they will do it. We don't really have any control over that. And again, if you watched this before, my experience has been that most physical consultatives are kind of a waste of time. Mental health consultatives can, often provide something useful, because the doctors that do mental consultatives are practicing psychologists who don't really, they're just doing their normal day-to-day activities or making a little extra money. The ones that do physical, not always, but many of them are the industrial clinic doctors that insurance companies use for reviews to deny people with long-term disability claims. But specifically to answer your question, it's not because of insufficient evidence. It's to develop the record and satisfy the burden. And it's really kind of a judgment call by the adjudicator. And secondly, is we upload things as soon as we get them. Typically we'll go through it to make sure there's no duplication, but we'll upload it directly. And then it has to be processed by the adjudicator. What I mean by that is the adjudicator gets the evidence. It then has to be sent to one of their medical experts to review, and then it comes back. So there is let's call it an information medical record gathering process at the administrative stage and initial recon, where we don't really know, where they are in that process. And again, I've talked about this as well, is you may look on your My Social Security account, it'll say 30% done or 40% done. That doesn't mean a hill of beans. They're going to get to it when they get to it. But again, consultatives are just one of these things that some adjudicators are going to just do it on every case. Others are going to be more specific. But I've had cases where the CE, the consultative, comes back really unfavorable to us, but the rest of the record is strong, and the judge ignores it. And I will, by the way, tell the judge, and I will tell my clients, I'll tell you, if you go to the consultative and it's a real waste of time, the doctor spends 2 minutes with you, doesn't really spend, ask any questions, doesn't, do any kind of physical exam, let me know, make a note of that. And then at the hearing, during my pre-hearing brief, I will object to it, or I'll ask the judge to give it minimal weight. Most judges realize that the consultative evaluations are not all that good. In fact, I'm seeing a lot of them now. They're done not even by doctors in the physical consultatives, but they're being done by nurse practitioners, which again is fine, or they're being done by PAs. That's fine because again, PAs and nurse practitioners, can certainly do appropriate evaluations. The problem is a lot of these consultatives, it just seems more on the physical side than anything else. They don't discuss any functional issues at all. They may talk about, that you reported this and this is what the exam showed, but they won't say anything about how long you can sit, stand, walk, kneel, crouch, crawl, things like that. So, they're of limited value. And, in my brief, if I don't see any, I just did a brief the other day on one where I referenced it, and there was no discussion whatsoever of my client's physical capacities. Well, didn't tell us anything because Social Security is all about what you can do, sitting, standing, lifting, carrying, things like that, if it's a physical problem. And so we need to know that stuff. And so I just objected, saying, didn't talk about it, and give it little weight. I had another one where the judge sent my client out for a post-hearing consultative evaluation. Actually, it was a interrogatories, which were like written statements to a doctor who reviewed the record, and the doctor didn't say anything, and I, really functional, and I objected to it. I said, give this no weight at all. The doctor didn't say anything. It's boilerplate. He just, kind of repeated. He made these conclusions, but there was no basis for it, but really made no comment about capacity. So, there's a lot of room for me to do my thing if these consultatives are not very useful. But again, I think it's really more about developing the record and Social Security feeling like they need to satisfy their burden. And again, we get the records in as soon as we can, but after that, when it gets evaluated, is obviously beyond my control. Okay. Sarah D. Good question. I have a diagnosis of sleep apnea on top of chronic anemia, insulin-dependent chronic diabetes, PTSD, major depressive disorder. What I'm really struggling with is a chronic fatigue and insomnia. I've actually just worked on a case. It's coming up maybe tomorrow or next week, where my client has severe sleep apnea. Normally sleep apnea is not a disabling condition in the sense that, not getting non-restorative sleep might limit you from doing complex tasks, but it's probably not going to be completely disabling. However, in the context of anemia and other types of things, that non-restorative sleep could be enough to push you over the edge as far as meeting the definition of disability. So I think, what I would probably tell you to do is keep a sleep diary as to how many hours of sleep you're getting and how many times you have to nap during the day, because taking unscheduled breaks to rest during the day is a real problem. Employers are not going to tolerate that. Realize everything that Social Security is doing is a judge is doing, an adjudicator is doing. They're looking at this through the lens, is maybe a good way to put it, of how these medical issues impact you potentially in an entry-level work environment. So you don't win by diagnosis. You don't win because you have sleep apnea or anemia or diabetes. You win because the sleep apnea creates non-restorative sleep, which interferes with focus and concentration. Anemia might make you weak, that you need to rest during the day and take 2 unscheduled rest breaks of 30 to 45 minutes, or that you might miss 2 or more days of work per month. These are things that if you add to a job profile, and let's say you're in a job interview and you say, well, Mr. Employer, I have sleep apnea, so 3 days a week I have non-restorative sleep. I'll only be able to do those simple, basic tasks. In addition to that, I have anemia, which means I'm probably going to miss 3 days of work per month. I have diabetes, where my blood sugar gets out of control 4 or 5 times a week. It gets so high that I, need to take a break, lie down, take, some insulin, or the insulin pump has to kick in, and I need to lie down to let my blood sugar come back to normal. I'll be taking an unscheduled break every 45 minutes, 3 times a week, twice a day, or my blood sugar gets so low that I have to eat something, a sugar cube before I pass out. And again, that might take me off task for 30 to 45 minutes. My fatigue is such where I'm likely to miss 2 or more days of work per month. When you put it in those terms, you start to see no employer is going to tolerate that. And that's exactly what vocational witnesses do at hearings, is the judge will ask a question. And of course, the vocational witness is limited to answering the question the judge asks. But the vocational witness will be asked a question that will include these limitations. And the VE will then testify that here are jobs that this person could do. There are jobs, somebody that has non-restorative sleep that would need to be doing entry-level 1 or 2-step jobs. There are plenty of light or sedentary unskilled jobs that don't require any thought or change of change in the workplace or decision making. But when you get to missing 2 or more days of work per month, or being off task is the term they use, for 15% of the day or more, 3 or 4 days a week, that is unacceptable. So our goal is to prompt the judge to ask questions of the vocational witness that have very, very severe limitations. And so what I always tell people to do, what I do, is when we're doing our pre-hearing, let's identify those specific problems. So I'll say to my client, how much, let's just go through what I do. How much can you lift? Well, not very much. Well, what does that mean? So is it 10 pounds, frequently, which is going to be 2/3 of the day? Okay, 15 pounds occasionally, which is maybe 1/3 of the day. That is a limitation that we can put into a question. So if I ask you how much you can lift, I can lift about 10 pounds pretty comfortably, 15 pounds, once or twice. Okay, that tells us something. How long can you stand without leaning on something? Well, I can stand, like in the Department of Motor Vehicles, I could stand for 10 to 12 minutes before I have to sit down. Well, that's going to limit the types of jobs. You can't do a counter job, for example, where you're behind a counter someplace, or how much can you walk? I can walk about 15 minutes. Well, that's going to eliminate jobs where you're going to be walking most of the hour. What's the total amount of walking and standing you can do? Oh, about maybe 2 to 3 hours a day. Well, that's going to eliminate light jobs, because light is defined as standing and walking up to 6 hours a day. So again, you see how we use these limitations that you testify to, and of course the medical evidence needs to support as well, to get those questions asked that are going to get us a result we want. Obviously, the judge doesn't have to believe your testimony, but at a minimum, you want to give the judge testimony that if he or she does use it, will result in a favorable decision. And I'll tell you, I've been before judges that they will take your testimony word for word and plug it into a question. And if the testimony is at a disabling level, especially if you meet the grid rules over age 50 or age 55, your chances of winning go way, way up. So you want to present, they call it presenting a prima facie case. It's a Latin term for, on its face, a winning case. So you need to know before you go in how much what your capacity is for sitting, standing, walking, climbing, kneeling, crouching, stooping, crawling, things like that, getting up off your hands and knees, getting into a bathtub or getting your shoes and socks on. These are all things that can translate into functional issues. If you have problems with focus and concentration, how often does it happen? Is it something every single day, 3 or 4 days a week? You really want to quantify as much as you can the limitations you have, so that the judge can plug those into a question. And the more you can give the judge specifics about that, the better it will be. Again, the judge may not take everything you say and plug it in, but some judges will, at the very least, give the judge something to think about, so that, if worse comes to worse, I ask that question and the vocational witness says, based on that, there's no jobs the person could do. And later on we have to appeal, and the appeals counsel could say, well, we find the claimant's testimony consistent with the medical evidence, so we're going to send it back to the judge to ask hypotheticals that are consistent with the claimant's testimony and medical records, which basically means you win. So if you see what I'm saying, you want to be very, very specific in your preparations for those kind of questions. All right, Trish Wade says, good evening. Good evening to you, Trish. We see Trish a lot here. Um, and Sarah D is saying, okay, talk again, daytime drowsiness, sleep medicines and medication side effects are a big deal. So again, Sarah has talked about she has sleep apnea, chronic anemia, insulin-dependent diabetes, PTSD, major depressive disorder, but she's really struggling with is the chronic fatigue and insomnia, limits what she can do during the day and medications. She's 39. I will tell you the biggest issue that you've said so far is your age. It is becoming more and more difficult to win when you're under 50. And, I'm just going to flat out tell you, I'm seeing more and more cases that I think should be approved that are people that are under age 50 are not getting approved. There's a gentleman that will probably be on later tonight. We talked yesterday who I represented, good case, should have been approved, 48 years old, got denied. And I just think I'm seeing more and more of that. So, Sarah, I would tell you that, I'm not saying it's impossible and you get a good judge who believes it, but your age is going to be a factor. So I would tell you the more you can get documentation from your doctors about, the effect of the side effects of these medications, the more you have a sleep diary, a pain diary, things like that, the better it's going to be. But, being 39 is going to make it more of an uphill battle because Social Security, I sense, is they're telling the judges, look, we have a trust fund running out of money in 10 years. And so we got to be really careful about who we approve. And if you approve a 39-year-old, that person is going to be claiming benefits on this trust fund for the next 25 years. And they don't want that to happen. So that's going to be the big issue. But, medically, you've got a good argument. But that's the problem. Melanie Frost says hello to Trish. Like It Is says, hey, Jonathan. Like It Is here a good bit. Jen, my loyal paralegal from Lincoln, Nebraska, is in the house tonight. Sarah D says, thank you for your insight. My pleasure. Johnny Doster's not been on for a while, but good to see you, Johnny. And Braves, I like it. Go Braves. Yeah, the Braves, I'm in Atlanta. Maybe, Johnny, you're a Braves fan either in Georgia or you're just a Braves fan. And the Braves, everybody thought they were going to be really good. They started out the year terribly. They lost a bunch of games, and they've been on this 7 or 8 game winning streak, which is a good thing, but they have a lot of ground to make up. And then their best pitcher, this guy Spencer Strider, just got put on the disabled list for a hamstring pull, which is never good because I think it's a hamstring pull. Because those things take a long time to get better, and you hope that Strider is not just an injury-prone pitcher who's really good, but go Braves. Melanie Frost says, "What's the difference between a remanded hearing from federal court and the old ALJ hearing?" Well, it's the same hearing. I mean, basically, the hearing is done by an ALJ, administrative law judge. A remand from either this appeals council or federal court means that the next level up, the appeals council or the federal district court, has said in a written decision to the judge, you need to do another hearing because you made a mistake. You did not ask the right question. You ignored a functional limitation when you're hypothetical. You did not analyze this medical evidence properly. I had Adriana De La Torre on a few weeks ago, who's an appeals lawyer, and I'll try to get her on again at some point. But she talked about this, is that the mistakes that the ALJs make is that they don't include all the limitations in their hypothetical. And part of the reason is that the ALJs don't actually write the decision. So what will happen is the ALJ will hear the case, kind of make a decision. I'm going to approve it. I'm going to disapprove it. They send it out to a writer in a different state, somebody who was not there, along with the audio of the hearing. The writer will listen to the audio and draft up a decision based on what the writer thinks is a good rationale, with some good input from the judge, sends it back to the judge, and the judge will sign off on it and release it. Well, if the writer didn't pick up on something at the hearing or reviewed the evidence and missed something, then there is going to be a disconnect someplace. And so, let's say that there was a lot of evidence in a file about, let's go back to Sarah's case, chronic fatigue. And there's clearly from multiple doctors that Sarah has a fatigue issue arising from, poor sleep, from her diabetes, from medication side effects, whatever the case may be, that she is not well rested during the day. But there is no mention of non-restorative sleep or fatigue in a hypothetical that the judge used to deny her case. Well, that would be reversible error, in my opinion, because you would then argue the appeals counsel is that the ALJ did not include any reference to fatigue in his hypothetical. So it wasn't even included at all. Well, it's severe condition. It's medically determinable, and it should have been addressed. And so the ALJ could have said, and this is where it gets a little tricky. The ALJ said, "I've reviewed the evidence about fatigue, but I find that the fatigue is minimal. I find the fatigue, only affects the claimant, occasionally, and it's not enough to really change her capacity, or it only reduces her capacity from complex instructions to simple instructions, but I'm finding she could do a simple job." The appeals counsel, the federal court, is not going to disturb the judge's interpretation of the evidence unless it is totally way off. I mean, if the judge said, there's no evidence of any back problems and there's 3 herniated discs, that's something different. But if it's, let's say, about fatigue, which is a little bit more subjective, and the judge makes an evaluation of it but decides that it's minimally a problem, that's probably not something the appeals counsel is going to disturb. But if the judge ignores a medical problem, and doesn't include it in the hypothetical at all, I think you could make an argument that that is something that needs to be addressed. And so the appeals counsel will send it back to the judge saying, you've got to consider fatigue. You've got to consider non-restorative sleep. And the judge could do another hearing and then consider those things and decide they're not disabling, and you lose again. But if you read between the lines, what the appeals counsel is saying to the judge, we think this is a real problem, this person's fatigue, so wink, wink, consider it, which is really what they're saying is we think it's a big enough problem that you should have approved this case. Some judges pick up on that. Other judges like, I don't care what you're implying, I'm going to do what I'm going to do. So some judges deny it again. It's just going to depend on the judge. But a lot of them, in my experience, will pick up that the appeals counsel or the district court went to the trouble of remanding it because the judge made this mistake. It is therefore, let's call it harmful error is the legal term. Therefore, they're sending a message that the judge needs to receive. There's one case, I've talked about this before. There's a judge, that I appeared in front of a number of times, not my favorite judge, I'll flat out tell you, who denies almost every case. And I've got him remanded a number of times because he's sloppy, in my opinion. And one case, he got remanded that the appeals counsel, it was a fibromyalgia case of all things, which was really hard to win anyway. And they said that, the claimant's testimony needs to be given due consideration, which is what they're saying is they believed her. And so the judge picked up on that to his credit, but he wrote this, in his decision, there was a 1.5-page footnote where he's basically saying, I'm only going to approve this case because the appeals counsel is forcing me to do so. I don't believe this case, this claimant. I would deny this case, but for the appeals counsel. And, I'm doing this under protest. And of course, then he disallowed my fee agreement, which eventually I got paid on. But, but the point is that he picked up that the appeals counsel, wanted him to approve this case. He was not happy about it, but he did what they wanted him to do. Other judges are like, I don't care what they're telling me to do. I'm not going to do it anyway. But, but that's the thing. So normally if it's a remand, it will come with instructions, and the instructions are many times a kind of a wink, wink. This is what you need to do. And sometimes judges pick up on it. Usually they do. Sometimes they don't. Big O says, hello or hi, everyone. Hello, Big. Stephanie says, I've been trying for over 10 years. All my credits have been found a liability at one of the court days, but won't approve me. I'm 54. Okay, so again, let's just kind of break this down. You've been trying for 10 years. So realize when you stop working, your credits follow you for about 5 years after you stop working. So if you haven't worked in 10 years, then your insurance for SSDI probably ran out 5 years ago. Now, you may say, well, I'm going to ask for an onset date going back 5 or 6 years when I was still insured, and you can certainly do that. That is a real uphill battle because you're trying to prove you became disabled, 5 or 6 years ago, getting the evidence together is really, really hard. And also, I'll just tell you, when you've been denied, especially if you've gone to a hearing and been denied multiple times, it's hard to then change things up. Now that you are 54, which certainly helps being over 50. And if you have a physical issue, then when you're over 55, the grid rules come into play. So I've had cases that were denied when somebody was 48 or 49. When I got them, they were 52, we won. Or I got them and they were 56 and they won because they were limited to light work, let's say at 56, and the grid rule came into play. In fact, there is some case law out there that says if the judge found your residual functional capacity to be light or sedentary in a prior hearing, then they can't come back in a second hearing and decide without a lot of evidence that you've got increased capacity. So, you may be able to say, well, back when I was 48, I was found to have sedentary functional capacity. Now I'm 54, and if I'm still a sedentary, then I meet the grid rules. But I think, again, it's an uphill battle when you've been denied multiple times, and especially if you've gone to hearing and lost at the hearing. And the other thing is that, you go to a hearing in front of a judge, and then you try to apply again, go through the process, go in front of the judge. It can be the same judge. So if you happen to draw a low-paying judge, and again, there's all kind of places you can go online to look, you got a bad judge, then you can stand in your head and hold your breath till you turn blue. It's not going to make any difference. So, then you have to say, well, should I move? Should I get to a situation where I at least get a different judge? And I've had that happen where, I've had cases denied, by one judge, and then my client moved, and the judge retired, and then we get an approval by the next judge. So, a lot of factors in play here. So I would say one, is your age. Number two, do you know your date last insured? Number three, what do the prior decisions say in terms of your functional capacity? Are you stuck with a low-paid judge? A lot of things going on there. But it is more of an uphill battle when you've been denied, especially the hearing. But a lot of things change, and age category change is probably the one thing that can make the biggest difference to get you in a better position for an approval. YouTube user, how many cases do I do every week? I have been trying anywhere from 3 to 5 or 6 a week. I had a week a couple weeks ago where I had, I think, 7, but I try to keep it to 3, 4 a week. Maybe, and I don't mind doing a couple of, let's say if I had 2 on Tuesday and 2 on Thursday, that's a pretty good rate for me. I can do that without a lot of problem. I've gotten to the point I know what I'm looking for in preparation, but that's kind of my thing. I've toyed with the idea of maybe growing things a little bit, adding another lawyer, my daughter possibly. But at this point, we are still keeping it just me. Again, that may change down the road. I just like, we've got a pretty good system here in terms of we're opening 15 to 25 cases a month, and I'd say 5 or 6 of them get approved administratively, and then if I'm trying 15, 18 a month, that's a pretty good range for me. Again, I'm pretty selective. I like to take good cases because again, it's a lot of work, and if you take cases that are it's a real uphill battle on. I'm just finding that I just know what judges are going to approve. So, but that's kind of my number. If you to answer your question, I'd say anywhere from 2 to 5. Well, probably one that say maybe 3 to 5 or 6 per week is about average for me. Like it is says hello, Jen. Okay, Jen's fan club there. Just received a voicemail. RD says, did not come on call ID. They call without an appointment. Will they ask in the first phone call? Well, if you just applied, they will just confirm the information you've got. And you raise a really good point, RD, and that is that there's a lot of phone scams out there. So if somebody calls you and says, without caller ID from Social Security, and says, hey, I'm from Social Security, I want to go over some stuff. Is this really from Social Security? That would concern me, and I don't know what they're doing to address that. As far as if they're telling you they're going to be calling you, or if they can how they verify who they are. They should know a lot of information. Certainly, they shouldn't be asking your Social Security number, your date of birth, things like that. You should be asking them to verify who they are, ask for the name, ask for their ID number, things like that, because this is a real issue. Because there's scam calls, and the last thing you want to be doing is giving out personal information to some scammer. And they're getting real sophisticated out there. So I'm not sure what Social Security is doing, but that would concern me that there's no caller ID on it. But it could be legit. It may not be. I don't know. Jason Riley. Okay, it was approved. That's great. The judge told you you're approved. That's great. In fact, I had two cases on Tuesday. Same judge out of Houston, and he announced both of them. He's going to approve them, and that's ideal. I really like when judges do that. In fact, my buddy Gordon Gates, I'm trying to get on here. I'm not sure if Gordon is. There's the NOSCR conventions this week. The National Organization Social Security Claimants Representatives is going on in Washington. I couldn't go this year. Went last year. In fact, that's when I did my first live stream. But I got to know a bunch of people are going, so I'll kind of get the lowdown. But Gordon may be there. I don't know. But I'm trying to get him on. But he did a blog post about this very issue, and that is that how nice it is when a judge will do that, because you'll know what's going on as opposed to having to wait and guess. So the judge told you you're approved. That's good. Again, you'll get your letter in the mail in about 3 to 5 weeks. It has to be written up. That's the going time at this point. And then the money would come about 2 or 3 weeks after that. So it'll be 3 to 5 weeks to get your written decision. Fairways says, you have not had much luck with chronic fatigue, fibro, long COVID, although I just won a long COVID case, a very interesting case. My client was highly educated, had a really very, very sophisticated, high-end, IT type of job, developed long COVID, not just from the COVID, but from the vaccine, and the judge approved it. Now, he was in his 60s, which helps, late 50s, early 60s. So, he was able to, show, and basically, and what Fairway is asking, any advice with those invisible illnesses to help strengthen their cases. I think that, diaries can be very useful, whether it's fatigue diary, a pain diary, a, sleep all day type of thing, that can be helpful. If you can get statements from former coworkers who've observed you, who can talk about the problems they saw you having, if you can show that your absences toward the end of your time at your job became more frequent, if you have a doctor who's willing to go on record, especially a rheumatologist or maybe a pain doctor who can go on record to say that these, the symptoms you're experiencing are very, very real. With long COVID, it seems like the things that really move the meter most are breathing issues, like I had that in my case, and cardiac issues. So, breathing problems, meaning that, shortness of breath on a regular basis, hard to, breathe in temperature extremes, or, respiratory irritants, heart issues, heart palpitations, blood pressure all over the place, medications not being effective, keep a medication type of diary. Those kind of things can be helpful. So I must say that in invisible illness cases, sometimes the non-medical evidence, the statements from former coworkers, supervisors, statements from third parties, the diaries you keep, those can be very helpful. Getting a doctor who will basically say that, we've tried multiple different therapies, nothing has worked, that can be helpful. And those are really the things that I think, going to a specialist, like, again, I'll go back to my case, just got the approval yesterday. He had found a long COVID clinic in a different state. He's in Georgia, and he found, I forget where it was, but it was in Arizona maybe. And so he had literally gone out to this long COVID clinic, and he had undergone a procedure. He was having I forget what it was, something abdominal, and he actually underwent a procedure to, increase blood flow or whatever. So, he basically demonstrated he was going to do anything he could to get better. And it, helped a little bit for a while, then it stopped helping, but he was seeking a treatment from multiple specialists. So that can be helpful. I think if you're just going to go to your family doctor, that's going to make it really, really hard. If you're trying an invisible illness, you got to find one of the specialists, somebody who does these kind of cases. Lyme disease, there are people who specialize in treating Lyme disease. fibromyalgia, rheumatologist. It could be, a chronic fatigue, might be a rheumatologist, as well, or maybe a sleep doctor, immunologist, infectious disease doctor, something like that. So I think if you get a specialist to offer an opinion about what's going on with you, that can make a big difference as well. So those are some of the things that I would try to do. And again, these cases can be won, but you need to just assume the judge is going to want more than what your family doctor is saying about your capacity, because that's almost certainly not going to be enough. And obviously, if you're over 50, even better over 55, that's going to make a difference for you as well. Stephanie says, Stephanie's a person who's been trying for about 10 years, and she says, I have 15 diagnosed conditions. And Stephanie, I'll tell you, that can be actually work against you. Sometimes when people have 15 conditions, the judge's conclusion, right or wrong, is that you're a hypochondriac, that you are, you have multiple conditions, that some of this stuff is in your head. I'm not saying you are or that's in your. I'm just telling you this is what judges think. So I'm more of a fan, if possible, and sometimes it is really 15 conditions, but especially if they're more subjective conditions, I try to first focus on the more objectively determinable problems. So if you've got back issues and MRIs, that would be one. But I would probably tell you 3 or 4 conditions is probably an easier thing for a judge to absorb than 15. When you get to 15 conditions, it's very hard for a judge to sort of say, well, I think this person really has 15 things going on with her. Maybe you do, and maybe you'll be one of the rare cases where that's the situation. But a lot of times, among the 15 might be a fatigue problem, or it might be a, sleep apnea problem, or it might be, myofascial pain without a specific cause. And so again, many times it can become a subjective situation where it's just going to be really hard to convince a judge on that. I would almost tell you to narrow it and focus on the 2 or 3 things that are most disabling. And if you can find, conditions that have objective evidence behind them, that's going to go a longer way. So again, I'm not, telling you no. I'm just telling you that is that is potentially a problem. Afsana, how are you doing? How are you doing? I still owe you a phone call. I know. Crazy week. And I think I told y'all last week we had some family issues that have really taken a lot of time up, but that seems to be resolved. And in fact, I took my relative to the doctor today, and things are looking up. So I'm going to have a little more time because my time has just been really sucked up, either with hearings or taking people to doctor's appointments. In fact, I'm going to make a note here to call Afsana. Okay. Right. Calvin H. What impairment is SSD looking for you apply with overactive bladder? And that, by the way, can be a very disabling situation, because it might mean you have to use the restroom multiple times an hour. Interstitial cystitis is the thing that comes to mind. Overactive bladder, it can be just something even simple as calling it that. But again, interstitial cystitis. What the important thing is, how frequently are you having to go? And realize that if you're having to go once an hour and you're in the restroom, remember we're quantifying this, you're in the restroom for 5 to 7 minutes an hour, then you're talking about an 8-hour day, 40 to 50 or 55 minutes, you're not working. Well, that's a lot of the day to be quote unquote off task. And most vocational witnesses would say if you have to take an unscheduled restroom break, every hour, every 45 minutes, that is excessive. So I think you want to quantify it as much as possible, but having a diagnosis would be helpful. And also, I'll tell you what's going to be helpful is that many times what doctors will do to treat that was they'll do a bladder extension where they'll fill your bladder full of fluid, so many times under anesthetic, to stretch it out to give you more capacity, or they'll give you medications that might reduce the inflammation and the urge to go. And, if that doesn't work, then that gives you that stronger argument. But you almost need to go through some of the protocols, even if they're not real pleasant, to go through all that kind of stuff. But, when they fill your bladder full of fluid, And again, without going into detail, I was with a person who had that done, a relative of mine, and it was pretty crazy to observe. I was kind of looking at it like that because I don't really want to see. But he was catheterized and they filled his bladder full of fluid and they wanted to see how long it took to empty it. Um, and those can be really debilitating conditions, as would be things like irritable bowel disease, anything in the bowel bladder area that causes excessive restroom breaks. Most judges will almost always assume that that's going to be work prohibitive if it is well documented. So those can be very, very good cases if it's properly documented and if you've shown you've done at least the non-invasive, the medication way to deal with it. But if you've gone through the invasive and it doesn't work, again, invasive, I mean, having your bladder filled or having some sort of a minor procedure, and it doesn't work and you've got support from a urologist, that's going to be a pretty good argument. Again, even better if you're over 50, but even under 50, that can be still a winning case. Sweet Candy, how long does it take to hear from a representative when doing an appeal? I get denied in March of 25. Normally you have 60 days to file an appeal, 60 or 65 days from the date on your denial. So if you got denied sometime in March, you've got until sometime in May. I would say within 25, 30 days, you should be getting that appeal filed sooner if at all possible. Again, sometimes, reps get busy and whatever, but I wouldn't want to wait until, you're in month, you're getting close to the end of that second month. That would not be good. So I think that, now you've been denied in March. I think you need to be, your attorney rep needs to be reaching out to you about now, certainly to get that appeal done. And again, sometimes the appeal can be it can take a little time because you've got to update the medical records and so forth. So you didn't say whether they're working on it or not. So there's a difference between just starting on it and maybe getting it completed. Okay, Mark is one of my clients, and Mark, I mentioned before, under 50, it's really hard, and Mark knows that because it's under 50 is really, really hard. So I would agree. I think if you're under 50, it's hard to do on your own because you have to have. The way I would look at it would be if let's just use on a scale of 1 to 10. If you're over 50 or 55, you need maybe 6 or 7 on that evidence scale. You're under 50, you need to be 9 on that evidence scale. You got to have a lot of evidence and a lot of compelling evidence, maybe creative evidence like statements from coworkers or pain diaries, things like that. You got to get a little creative because judges just aren't approving cases, even good cases. They're not approving, which really is frustrating. Vince, hello, Vince. I hope the weather's gotten better for you up in the Midwest there. It should be. Nice says, big pardon. When does SSDI turn to retirement? At full retirement age, so 66, generally speaking, it just changes automatically. And you should see no difference in your benefit, but it just goes from one different fund to a different, one fund to another. I'm not sure whether you can say you can stay on disability to. I know you can do it until full retirement. I'm not sure you can go beyond that, but it's going to be at least to full retirement. Janelle Barrows, my lawyer has my bank information. Still receive a call from SSI if I'm approved. Well, again, the lawyer having the banking information is not important. It's SSA has to have the banking information. This is one of the areas where all the security issues that Elon Musk is all concerned about is going into play, and that is that there was a perception, at least Mr. Musk believes, and some of the folks who are working with him, that there has been a real problem and that people are calling up Social Security saying, I am Janelle's attorney, or I'm Janelle, and you need to change my bank account from Bank of America to Ally Bank and put my money in there. And it turns out it's fraudulent. And so Janelle doesn't get her check because somebody changed a bank account. Is that a real problem? I don't know. I get the sense it's not as big of a problem as maybe we're being told it is, but nevertheless. I think if you give Social Security your bank account information early on, that's a good thing. So that way, if they do approve you, they've got a place to make a direct deposit. You absolutely want direct deposits. You don't want checks. In fact, I think they're moving away from checks, period. So you want to get direct deposit. You also don't want to do one of those cash cards like you see at Walmart. I have personally known people who've been ripped off on those things. So stay away from those things. But getting a bank account where you get a direct deposit for Social Security is really the way to do it. But it gives Social Security that information directly. And now if you want to change it, you've got to go in and prove your ID and all that stuff, which again is probably not a bad thing. But many people felt like it was being done to make life difficult for people. I should discourage them from applying. I'm not so sure of that, but I think that there is a lot of fraud out there. As much as they think it is, I don't know, but so are we solving a problem that is more possible, or is it one that's actually going on? I don't know. Okay. Trish Wade says, after you use your 9 months of trial work period and you enter the 36 months of extended period of eligibility, can you work beyond those 3 years as long as you never go above SGA? The answer would be, if you're on disability benefits and you stay below SGA, then you would not put your benefits in jeopardy. The issue is if let's say that SGA in 2025 is $1,620 a month. Let's say, for sake of argument, that you are working a job and you're earning $1,400 a month, month after month. Social Security might look at that and say, well, she's able to earn $1,400. What is stopping her from going up to $1,600 or $1,700? And might they conclude that there is it's called income suppression going on, or might they conclude that you are intentionally not asking for hours to go over the 1620? My point is, it might trigger a review. So the technical answer is, as long as you stay below SGA, you do not go into overpay status, but you might trigger a continuing disability review if your regular earnings are just below SGA. You're at 1,900, even a smaller amount might trigger, at least if you do the short form CDR, and you show earnings, a human being will look at it, and they'll look at it and say, well, is there a medical improvement that allowed this person to do it? And you might have to prove that the most capacity you have is $1,400 a month or $1,200 a month. The problem is, if they move to terminate your benefits, you get an opportunity to say, well, I want my benefits to continue while I appeal. Okay. Or I don't, you can terminate my benefits while I appeal. Well, if you ask for benefits to continue while you appeal, no past due benefits, so you'll have to pay an attorney out of pocket. And you're talking about doing a hearing, you might be looking $3,000, $4,000, $5,000. Not feasible for most people. If you say, well, I don't need my benefits to continue while I appeal, you got no money coming in for the next 2 years. Also not very palatable. So they put you between a rock and a hard place. My point being that, if you decide to work after you're approved, you need to really factor into your calculations the risk that ongoing work might trigger a CDR. It doesn't have to. And again, if you've got a really serious problem medically, that might be enough to kind of overcome that. But, if Social Security sees you working, I will tell you that a priority in Social Security is to get people off benefits. So, but they don't want to discourage people from trying to work. But if they see somebody who's working month after month after month at, let's say 85% of SGA or 90% of SGA, that's probably going to trigger a CDR. So that's the rub. That's what you got to be careful about. All right. So Afsana says to Blue Z, congratulations. Chan Tet, who's been here before, says hello. Hello, Chan. John Lee, my online website says DDS has completed the medical review and started a final review to make sure I still meet the non-medical requirements. That's usually a pretty good sign. That usually means that it's likely you'll be approved, because they're doing the non-medical part, which means they completed the medical part. Why would they do a non-medical review if they were going to deny you? It doesn't make sense. So I think that's a good sign. Main Event says, hello, Main Event. Eric Webb, what kind of hearing should you tell your attorney you want, phone, video, or in person? Great question, Eric. My personal preference is telephone, for the following reasons. I think live hearings, a couple of issues with live hearings. Number one is it limits me, obviously, because I'm here in one place. And, if somebody from California or Michigan or Ohio wanted me to represent them, I'm not going to fly to Ohio for one hearing. So I would have to refer them to somebody. So selfishly, if I want to take a case, I tell my client, look, if you want a live hearing, I can find somebody for you, but it won't be me unless it's in Georgia. So I don't really go with live hearings. Second reason I don't like live hearings is that Social Security is still using the COVID protocols so that they're literally doing one at a time. So you go to the hearing office, and I've gone a couple of times, it's empty. There used to be a full of people. They don't want a bunch of people in one place. So it's going to be slower to get your hearing if you do it in person. I think the third thing is that you have judges, and some hearing offices are bigger than others, but judges, are used to the virtual hearings, and they don't really want to be in a small room with somebody they don't know who's hacking and coughing. I mean, a lot of judges are in their 50s, 60s, even 70s. They don't really need to be exposed to a lot of people. So again, I'm not a big fan of in-person hearings. I know some of my colleagues think that, you really benefit from a judge seeing you. I get the logic, but I have not found that to be the case. I think judges like to be comfortable in their own home. And certainly my clients like to avoid paying parking fees and finding a hearing office in downtown, big city, things like that. So I'm not a big fan of live hearings. Telephone hearings tend to work great. Everybody's got a telephone, a cell phone. It's not a lot of technical things that can go wrong. And, judge can be focused on his computer, her computer. You can be focused on what your notes, whatever. They work really, really well. Video hearings work fine as well. The problem is, I will tell you just from doing a lot of them that, in about a third of the cases, there is a technical glitch. The judge can't see you. You can't see the judge. The recording equipment's not working. They use Microsoft Teams, but it just seems like more stuff goes wrong. And I don't necessarily see the real advantage to a video hearing. I mean, the judge can see you, you can see the judge, but there's not really any quote unquote connection in the sense of, a judge getting a sense of what you're all about. They're not going to be able to, you can't say, well, judge, I've got a bad foot. You're not going to, here's my I can get my foot that high. Maybe I should try it that way. Okay. You're not going to do that. Okay. You're going to put your foot up there and show the judge. So, it's really, there's no real benefit to doing that. So I don't know that a video hearing is really that much more useful. It's kind of nice to see your client, to be sort of in the same virtual room. I don't mind that. And again, sometimes it's nice to see the judge, but I would say either a phone or a video hearing. My preference is phone hearings. I just think it's just less to go wrong. They work quickly. Their judges like them. There's really not a problem doing it. They're used to doing it now, so it's the norm. That's my take, just to do a phone hearing. If you're asking me. So John, yeah, we were saying before, I think that probably is a sign of that. All right, here's a call to get the case evaluation. Let me also put this one up here, that if you're enjoying this and you'd like to leave me a review, please, that would be helpful. I've gotten some really nice reviews, and that benefits me because, Google and Avo, all these other places, people are going to look about lawyers. They can say, well, this guy's, he's telling people what he knows, showing what he knows. He's been helpful, and it just helps me build my practice. And so, if you're up to doing it, I really appreciate it. Okay. So Trish tells us that her husband got an ALJ approval with a change of onset date to the day he turned 55. Again, more and more common. Thank you for we're welcome about that for videos and valuable information. Yeah, I'm just seeing this more and more. A lot of people are. In fact, I had a hearing the other day where my client, was 54, he just turned 55 in February, last couple months ago. and his onset date was 53. And the judge is sort of throwing out things like, well, what's a 60-year-old? He just turned 60 in February. What's a 60-year-old going to do? Blah, blah. I'm thinking, I hope this judge isn't going to approve this case on his 60th birthday, because again, that would mean I don't get paid, because he just turned 60 in February, and he should be approved at 58. I mean, the grid rules I think would do it. So I'm hoping the judge doesn't do it, but we'll see. But I think that we're seeing more and more judges using the next birthday, whether it's 50, 50, or 55 or 60, to approve cases and change the onset date. Cuts out past due benefits. And again, it cuts out my fee, which doesn't make me very happy. I like to get paid for what I do. And I think it's somewhat arbitrary. So, anyway, yeah, that's not uncommon. So my point is, if you're 54 and a half at onset, don't be surprised if you are asked to change to your 55th birthday. I just responded. There's a gentleman I'm going to be talking to tomorrow about a potential case. And, he had sent me some information to look at. And so I wrote him an email, just kind of telling him this is what I want to talk about. But my point was, he was, if I'm not mistaken, 48 or 49 at onset when some particular medical event happened. And then he turned 50, now he's like 52. So I said, one of the things that may happen is at 50, the grid rules go into effect, because he's got some exertional issues that would limit his functional capacity. I said, at 48, you got to prove you can't do anything. But at 50, all you got to do is prove you're limited to sedentary work. So don't be surprised if a judge asks you to change your onset date. And we'll talk about that here. I'll talk about that more tomorrow. But my point is that is becoming more and more common. So if you're applying, I would just say this: if you could possibly wait and keep working until after that, that birthday, that 50th or 55th birthday, that might benefit you, simply because applying for benefits using an onset date, let's say within a year of that milestone birthday, 50 or 55, it's going to probably get changed anyway. So you might as well get paid working, if you can, for that extra year or so. So it's just unfortunately the reality of what we're dealing with. You would think judges would approve people based on what the evidence says, but again, they're being pressured to limit what they approve, and that's one of the things that they're doing, changing onset date. All right, No Sky is here, as he usually is, saying hello to everybody. Let me change the banner here. How about my contact, how to reach me there? Okay. Lily's the person who said she had uploaded documents to my portal. Okay, excellent medical support either way. If you have to file RECA, I'm so glad you're on my board. Yes, I have a nurse practitioner. Yeah, so you have a nurse practitioner. Lily's one of our clients, to your CE, which is very, very common. And, we'll just, we update the record, let the adjudicator know new stuff is here. What they do with it afterwards, we can't really control. What if you're fit, Paul Nightwolf? What if you're 55? How often do they review? Good question. My experience has been not that often. I'm not saying they won't review you, but I think that after 55, you're less of a target because you're getting close to retirement age. So I just, don't think that's going to be as big of a problem for you. Mark, again, Mark, I know we talked about this a little bit. We got denied on a case that should have been approved. And one of the things that we both noted was that the ALJ, as Mark put it, cherry-picked statements from the adult function report and left out statements that contextualize the statement. And so what he's getting at is that, there are statements on an adult function report, which is one of the forms you fill out. And the big picture, you've got to be really careful about what you say, because you put something on there and the judge can take out one line. It's, again, not the judge, it's the writer. So it may not even be the judge, or maybe the writer pulled it out that, I can lift 25 pounds, ... if my life depended on it. Well, if they leave out if my life depended on it, and you say I can lift 25 pounds, that's a whole different meaning. So Mark's point is that they, when you write stuff, you have to be very, very careful about how you write it. And I have videos that I give to my clients about how to write stuff on these forms. And I tell my clients, send me your forms and I'll review it. I don't want to fill out the forms directly because it's evidence, but if you send me the form before we submit it, I'll tell you this needs to be changed. So that would be something that just, I think you're right. You got to be real careful about that because they will cherry pick. Lulu says, okay, if you apply while you're insured and your case takes longer and they approve you after your date last insured, will you have any problem? No, assuming the onset date is before your date last insured. So here's the scenario. Let's say that your date last insured is June 30th of 2025. And you have a hearing in July or August of 25, and you're approved, in September of 25, but your onset date is September of 2024. Well, if your onset date is before your date last insured, it doesn't matter when you get approved, as long as you're grandfathered in if your onset date is before your date last insured. The issue that you run into is that if you are denied and your date last insured is run, you have to appeal, because if you don't and you reapply, your date last insured is already run, and they call it res judicata, which means that you can't go back and relitigate what was already been decided. So if the judge made a decision, you were not disabled, the decision comes out in July of 2025, but your date last insured was in March of 2025, then you reapply your SSI only. So that's why it can be a little bit dangerous. But as long as your approval, your onset is before your date last insured, you should be okay. And I will tell you this, I've had a couple of times where a judge will approve a case, but do it after the date last insured, which means my client gets approved, but not for SSDI. And that's hard to swallow because you've won the battle, but lost the war. And sometimes it's because the medical evidence. I remember years ago, I had a judge who was apologetic. My client was an HIV case, but he was sort of asymptomatic, and then he ran out of credits. Let's say in February of 2024, he became symptomatic in March of 25 or whatever. And the judge is like, if I could find a way to find that you were having symptoms before your date last insured, I'd do it, but there's just nothing there. And so, I'll approve you as of the date I see the symptoms, but I can't do it any earlier. The judge was aware of what was going on and at least gave the client the courtesy of an explanation. But, what I don't like is when the judge will change the onset date without even discussing it at the hearing to a point after the date last insured. It doesn't happen very often, but it does happen occasionally. So again, you need to know your date last insured. You need to know your onset date, and really, if it makes sense to amend that onset date to take away months where there is no evidence, that's probably not a bad thing to do. Okay. So Mark, again, we're talking about, a 4.5-year process, decision made. Yeah. And again, maybe, I think that, some judges look at your age, under 50, they look at some of the evidence, maybe a consultative evaluation, and they prejudge the case. Does that happen? Absolutely. I think some judges, in their mind, the profile is, I'm going to approve any case. This person needs to be over 50 with this level of symptomology for this type of medical problem. If it's a back problem, there needs to be a herniated disc or at least a bulging disc with, nerve root compression or something like that. If they're under 50, it's got to be a herniated disc, multiple herniated discs. They may have in their own mind what it takes to be convincing. And they prejudge a case. There was actually a case on the listserv that came up a few weeks ago where an attorney basically said that a decision got released before the hearing denying the case, and obviously the judge had been pre-written, and so everybody wanted to know, did it say anything about what the claimant testified to, because obviously the case hadn't happened yet, and I don't remember if it did or not, but I think the judge vacated that that decision and issued another one. But yeah, this happens, that they prejudge cases, and it's really frustrating. I don't think most judges do it, but some do, and I think that, but I do think that most judges have in their own mind, and it's really the same way I do, what does it take to win a case? And if I was a judge, okay, I'll look at it from this perspective. If I was a judge, okay, I'm looking at claims, and I see a person who's 35 years old with whatever the issue would be, I would probably expect to see more evidence than I would expect to see for a 57-year-old with similar complaints, because a 35-year-old is going to heal up faster than a 57-year-old, and you got the grid rules and so forth. I would hope that I would be more open-minded to say, okay, if the evidence is compelling, regardless of the person's age, they should be approved. But that's just me. And some judges look at it that way. Others are just, you're not 50, you're not getting approved. I had a case with a judge who's a 12% approval rating. She, of course, denied our case. Clients over 60 should have been approved. We're looking to appeal that one. So some judges are just not reasonable. Other judges, are okay if you're over 50, but not if you're under 50. If you look at the percentages, my opinion, this is just my rule of thumb. If a judge, the average approval percentage for a judge is about 48, 49% nationally. So if you have a judge in the 50s, that tells me that judge is kind of going into the case with the idea of, I'm looking for a way to approve this person, assuming the evidence is strong. I'm not going to approve just anybody, but I'm going to assume that there's a good likelihood they can be approved, and I'm okay with that. If they're in their 60s, that assumption is even stronger. If they're 40 to 50%, they're going into that case with not really any bias one way or the other. They're going to listen to the evidence and really try to do it down the middle. Again, probably more of a bias in favor of people over 50, but still open to anything. Under 40%, say 30 to 40%, these are the judges that just aren't going to approve you if you are under 50. Just probably not going to happen unless it's really compelling. Under 30%, they are assuming you are not going to get approved, and you've got to show by an overwhelming force of evidence that you deserve to be approved, and they're looking for reasons to screw with the onset date. That's my rule of thumb with judges. I'm not saying everyone fits within that category, but that is kind of my rule of thumb as far as when I see a judge. When I see a judge with a 30% approval rate, 25%, the assumption is that that judge is not looking for a reason to approve. And in my opinion, again, just my opinion, why are you a judge? If your goal is to not approve people, you should be looking at this saying, if I was a judge, again, I would take the position, anybody applying for disability, that's a really, really tough thing to do, to label yourself as disabled, to stop working, to not have money for a year. I'm going to assume that the person sincerely believes they have a significant medical problem. And if they've got an attorney, that the attorney has said to them, look, there's not enough here if there's not enough there. But if they're represented and there is some good evidence there, objective evidence, have gone to the doctor, I would be more likely to say, okay, I can understand, I'm going to at least give it a strong consideration. But some judges are not like that, but I'm not a judge. So, but I'm just saying that's how I would try to be, if I was, although I would not tie myself to a particular percentage. And I think that, I think every judge has got to make a decision based on that person's philosophy. But I would probably have in mind the criteria that I think would be for a winning case. Jim says, nice haircut. Thank you. Yeah, I got a haircut a couple of weeks ago. My hair, I don't know why this has always been my whole life. My hair grows really fast. So I get a haircut every month. If I don't get a haircut by the end of the month, it's just like gets out of control and way long. I don't know why. That's just me. And I'm fortunate because most of my friends that are my age, have receding hairlines and thinning hair, and so far so good. But but I appreciate that. But yeah, I got to get my hair cut. And I've got what they call, I don't know, I'm telling you all this, they call them crowns. There's like it goes the wrong way. So my hair is hard to cut. So there's only a few people who've been able to do it correctly. Or if you cut the crown, it causes it to stick right up. So I have to, in case you were wondering, I have to find a person who really knows how to cut my hair properly. But thank you for the nice words. A lot more gray than there used to be, though. I will say that. At least I got it. So. Okay. John Bray. I was diagnosed with osteoarthritis in my shoulder. doctor told me I needed shoulder replacement surgery. It's 48, still working. To get surgery for applying for SSDI afterwards. I think the medical needs to determine that. I mean, realize that to win disability, you've got to have a condition that's going to keep you out for years. I would say if you could certainly wait till 50, that would be helpful because that's going to make your case more likely to get approved. If you stop working, apply for disability, and then um, undergo surgery, or you undergo surgery, then apply for disability, at the end of the day, your options would be to stop working, not undergo surgery, apply for disability, and hope you get approved fairly quickly. Again, it could be a couple of years. You know, are you willing to not get yourself better and wait 2 or 3 years so you'll get on disability? I wouldn't. I mean, but if you get the surgery and it's successful and you're back functional within that year, you won't get disability. So the question is, can you, if you're dead set on getting disability, can you be out of work for at least a year to get that at least that 1 year benefit? You can make your surgical decisions on that, basis. But again, just keep in mind you have to be out for a year. I think the medical needs to define or to make the determination as to what you need to do surgery wise. Um, you know, Being on disability, again, it's going to take a couple of years to get a decision, 2 or 3 years. I wouldn't put your life on hold hoping you're going to get approved. You might not get approved, even with the need for bilateral shoulder surgery. You still might not get approved. You may get a low percentage judge. So I think let the medical dictate what you do. If it was me, I would get the surgery as soon as I could. Although, again, to hedge my bets a little bit, I would try to hold off until you're 50. That way, if the surgery does not go well or you have an extended recovery, you do have that, at least that way you get that year of benefits. So I would say wait until 50 before making a decision about that. But I wouldn't hold off on surgery with the hope you'll get on disability. I don't think that makes a lot of sense. Jeff says, I went to my doctor a couple of weeks ago. My PA says it's against hospital policy to fill out functional capacity forms. I go to my regular pain doctor in a few weeks. How do I ask him to fill out terminal limitations? First of all, that's a bunch of BS. It's against hospital policy. Why? Why would it be against hospital policy? What detriment would it have? They just don't want to do it. So, there's no national reason. There's no standard for that. Many doctors do it in hospitals. I think when I advise my clients about how to talk to doctors, what I would say is, you go to your doctor and say, look, I had to make a really difficult decision to pursue disability because I didn't want to do it. I was working, but I just could not continue. And I just got to the point where I'm just in too much pain. I'm having too many medication side effects, whatever the issues are, I had to stop working. And I want to get back to work, but I need, it's going to take me a couple of years to get the procedures to, improve my physical capacity, whatever it is. And I'm trying to get on disability. I'm doing so reluctantly. If you would help me in this regard, I'm not asking you to say I'm disabled. I'm just asking you to identify limitations. That if you believe me when I tell you I've got these limitations, but I want you to know how much I hate the idea of doing this. I think if you go with that attitude, I'm maybe being a little over the top and talking about it, but if you go with that attitude, you're going to find doctors more willing to help you. So I think you have to just really think about how you approach your doctor, and you want to make it clear. I'm not asking you to testify at a hearing. I'm not asking you to say I'm disabled. I'm just asking you to say, that I have limitations at this point, but that I am motivated to get those better. And I think if you approach it that way, it's more likely your doctor is going to help you. But that's how I would ask your doctor to help you. And I've had some success where I'll take a form or give my client a form, and we'll fill it out together and say, okay, these are the questions that I need answered. Questions 17, 19, and 24. And here's what I would like it to say. This is what's going to help me help you. And if you let your doctor know what he can or she can do to help you, many times doctors will do that. So if they don't know that that a question on the form about missing 3 or 4 days of work per month is really an important question. So if you draw their attention to question 19 on this functional capacity form, which says how often is this person likely to miss work, and they put in 2 days or 3 days a month, that's going to really help you. Or that I'm going to put this my patient's going to need to take unscheduled breaks because of pain, 3 times a day or whatever it was in the form. Let them know that's going to help you. That can be helpful as well. I think that doctors don't want to guess. Sometimes they want to help you, don't know how. And so if you can, with your attorney's help, show them what they can do to help you, that can really go a long way. But I think attitude is really, really important there. Jackie, okay. We won Jackie's husband's case on Tuesday, which is really cool. And yes, thank you very much, Jackie. They actually, you and your husband were really easy to work with. I mean, you were very diligent as far as getting back to me on things. You read my pre-hearing brief and you actually caught a mistake in it. I actually submitted a prior version of the brief and I needed to add a couple of things. So I submitted a second version of it, which you get in time. The judge was receptive to his testimony. He did a great job with his testimony. We talked about what to say. He did exactly what I suggested he do, and it worked out perfectly. So we got everything worked out great. So I'm grateful for you guys because you listened, which is really helpful. Attorneys really like that, and you followed my suggestions, and you were helpful to me getting what I needed. And together we did this. It wasn't, and your husband did the hard part, but you were a real aid to me to get this to the point where it was a winning case. So thank you. Tara says, hello, Jonathan. Jen, hello, Tara. DK says, I'm on disability, which is under $700 a month. How do you live on that? Is there a way to get more? Again, if you're an SSDI, theoretically you could apply for SSI and get the difference. The SSI is, I think it's like $1,000, but there could be offsets for that. But no, you don't get more money if your disability gets worse. And again, if you had a very low earnings record, that's maybe why it's so low. Or if you're SSI only and the 700 is the SSI minus some offsets, not much you can do. Yeah, look, my opinion is that SSI will trap you in poverty because you can't really work, and any assets you get will offset your SSI. So you get in a really difficult situation. If you're SSDI, again, big difference. You need to know the difference between the two. If you're SSDI getting $700 a month, you can still work and earn. You can use up your trial work period months and then work up to SGA. So you could theoretically earn $1,500 a month in addition to your 700. So you could get it to 2,200, which again is not a ton of money, but you could theoretically still work if you're able to do so. But $700 a month if you're SSDI. If you're SSI, you can't, but SSDI you could. But yeah, $700, but you can't live on $700 a month in 2025. No question about it. So hopefully you have friends or family that can help you, because otherwise you're in trouble. We got Jackie's point is we got a bench decision in her husband's case. The judge basically, and again, as I was talking about this before, I had 2 cases on Tuesday. Jackie's husband was one of them, and there was another one we had, which again, the judge was kind of making some noises about changing to age 60, although he didn't do that in Jackie's husband's case. So I'm hoping he won't do it in the other one. But yeah, the judge made a decision, and I was really appreciative of that. The judge in our case was an interesting guy. He was very direct. I mean, he told us he was ex-military. In fact, your husband, even they were talking a little bit about what branches they were in and so forth. Because your husband said, "What should I call you, Your Honor or Sir?" And the judge says, "Well, I'm ex-military, so I'm used to people calling me Sir." So I'm guessing he was, captain or lieutenant or something like that. So anyway, there's a kind of a rapport going on there, which is a good thing. But the judge in both cases on Tuesday announced he was going to approve. Both of them were good cases, people over 55, with strong arguments. And, like I said, I'm pretty good at spotting the good ones. And so, the judge made his life easy. And again, he has a higher than average approval rate, but you never want to assume that. So, but yeah, that worked out perfectly. Christina from California is here a lot. Christina, how are you? And good to see you again. Hello. Okay. ALJ gave me lawyer, left me, but ALJ decision. ALJ, let's see, lawyer left me, ALJ submitted for wrong information, got psych records full of lies, help me, I'm alone. SSI. Psych said I was drinking toilet water. I don't have water. At least I don't want to comment on I can't comment on your particular case there. What I'm sort of thinking is that you felt that the ALJ had inaccurate statements in the record. And as I was talking about before, on an appeal, the questions, were those statements material? SSI, it's going to be harder to find an appellate lawyer because the dollars are just not as great there. Realize that there can be inaccuracies in a decision, but if they're not material to the decision, then it's not going to be reversible. This business of saying you're drinking toilet water, a psychologist said that. Honestly, that's probably going to help your case because that's obviously a indication of a significant psychological conditioning. No disrespect, but most people aren't going to do that. So, more questions than answers here. But if you said you had a lawyer, left, I guess a little bit unclear whether you have a lawyer or not. But I would certainly ask a lawyer if you're within the 60 days to look at it for possible appeal. The issue you're going to run into is if it's SSI only, it's going to be hard to find somebody who's going to want to take an SSI case to appeal. Not impossible, but a little bit more difficult there. All right, JMR 1068204, which I'm sure there's significance behind that. One my case for SSDI, I got my back pay late February, my first payment on 1270 in January, and continuing on. I've done online surveys to supplement, use about $300 a month. I need to report this monthly. Then it's going to consider an employer, and it's like nobody knows. I wouldn't, again, the nobody knows part I would try to take out of your vocabulary. I think that it's going to be reported at some point as 1099 income. That, in my opinion, $300 a month is so small relative to trial work or SGA that you can report that at the end of the year. I mean, I know they want you to report it monthly if there's even a place to do it. If you want to go ahead and do that, I personally would probably almost tell you, report it twice a year, maybe every quarter, something like that. I think that's more than enough. You're not working at anything close to SGA. And I think that, they're so busy now. I don't know that you need to report that monthly. That's up to you. I know I've had some discussions with people about that. I would be prepared to report it, but my opinion would be twice a year is fine. I think, but that's just my opinion. But if it makes you feel more comfortable to do it monthly, do it. But don't assume it won't be reported. It'll be reported as 1099 income at the end of the year, and you may have to explain that. So again, if you twice a year you say, okay, I've generated $1,800 in the last 6 months, and then the end of the year another $1,800, $2,000. I don't think that's going to move the meter at all. And yeah, they can't get a hold of anybody to give you an answer. Right, so Lisa's got a number of things. Yeah, you've got some significant medical issues. Not sure why they would turn you down, because you've got a lot of issues there. Are they well documented? I don't know, but you've got, I think, enough disabling issues that should get you approved. Dennis, being on SSI 57, yeah, you could. Not likely. At your age. All right, JMR, this is to continue the discussion about the $300 a month surveys. Yeah, I mean, it's income. I mean, you're not really, you're doing work for the money. It's not like you're working, a full day, a full job, but it's more than passive. It's not exactly passive. Very, very part-time. Again, I think every 6 months, in my opinion, would be fine. And Lisa, again, I'm not doubting that you've got some disabling conditions, but why they would turn you down, I don't know. It sounds like you've got a pretty good argument. And Mark is below 50, which is the issue, and the DLI was after. So if he was 48 or 49 at onset, and the date last insured, or was before he turned 50, or in anybody's situation. Let's talk about Mark in particular. But if your date last insured is at age 49, if you're found disabled at 50, it doesn't really help you. So that's always an issue. Just you need to know the dates of your date last insured, your birth date, all those things. In fact, when I'm doing right before my hearing, what I have in front of me, I will have the date of application. I will have the alleged onset date of my client's date of birth and current age, when they turn 50, when they turn 55. So I've got all that right in front of me because that's going to be very relevant in most situations. All right. Well, DDS taken into consideration. I'm a commercial driver for 30 years. No way I'd pass the physical. 56. Again, if you look at the 5-step sequential evaluation process, which is what they look at, step 4 is, could you return to past relevant work? Answer is obviously no. So yes, that will be considered. You can't return to past relevant work. At 56, the grid rules are going to be come into play, assuming you have physical limitations. So you look at those. Go to gridrules.net, look at the light grid rules. And so if you're 56 or 55 at onset, you can't do past relevant work. There's no transferable skills to lighter work as a commercial driver. You're going to meet the grids at 202.06. So I think that, your case on its face, my gut would tell me it's probably a winning case. Probably a winning case based on that. What other SS programs can assist with low income from disability? Again, other than SSI, no, there's really nothing else. It's really, now you go into the state programs, state Medicaid programs, state, assistance programs, food stamps, things like that, but nothing else from Social Security. I'm now getting home health care for personal in the house, denied 5 times. We found the doctor lied in the letter, but worked for SSI. I get this sometimes that the doctor lied or the judge lied. Not that they lied. I mean, judges, doctors, they may have a bias, and they may put something in there to minimize what you told them or minimize their, the severity of a problem. It's really philosophy. I hate to put it, so, woo-woo out there. But some doctors, some judges just don't really seem to believe in the concept of disability. They don't want to find people disabled. I remember I was at somebody's at a dinner party one time, and I was talking to this doctor, not a Social Security doctor, just I'm not sure what kind of doctor he was, maybe a rheumatologist. And he said to me, he asked me what I did. I said, I'm a Social Security disability attorney. He's like, I don't think anybody is truly disabled. I mean, if you really had to work, you could work. And I'm looking at the guy saying, what the hell do you know about that? I mean, how can you say that? I said, I just said, with all due respect, Doc, I mean, I've been doing this for a long time. There are people out there who cannot work. First of all, Social Security doesn't say, you have to look how they define disability is, do you have a medical condition that prevents you from engaging in substantial gainful activity? And so that means you could theoretically work part-time and still be disabled, because substantial gainful activity is more of a full-time kind of thing. So what is the doctor talking about, full-time or part-time work? If they're over 50, they could still be able to do sedentary work and be disabled. If they're over 55, light work. So, for a doctor to say nobody's truly disabled, what is the definition he is using? Is he saying that everybody, that there's nobody he's ever seen that couldn't do something, that couldn't, work for 45 minutes in a day? Okay, maybe, of the people, his patients, 99% of them could get through 45 minutes a day doing something, and I'm sure there are people who couldn't even do that. But let's say in his practice, 99%. That doesn't mean that a lot more of them are not disabled as far as Social Security defines it. So again, I didn't want to get an argument with this guy at this dinner party, but I'm like, do you understand how they define it? What definition are you using? And so, and secondly,
have you ever lived, in a situation where you can't get good medical care, that the insurance companies are dictating what treatment you get? I just was talking to somebody the other day, and this individual we have a case coming up next week, and she was telling me, she's like, I had to have surgery, and the doctor said to me I needed a fusion, but the insurance company says we're not paying for a fusion. You've got to have a laminectomy first, which is kind of a trimming of the disc. So she's like, we went into this, I had to undergo surgery. The doctor told me a laminectomy is not going to solve your problem. You need a fusion because of the instability and other things. But I had to undergo surgery, general anesthetic, go under the knife, because the insurance company won't pay for a fusion until I've had a laminectomy first. So you got insurance companies dictating medical treatment. Okay. Does that make any sense to anybody? No, it makes zero sense to me. So again, you have some doctors that just, don't understand what disability means, what the implications of having an insurance company dictate care would be, what it means to, not be able to get in to see a doctor, but every, 3 or 4 months you're at the VA and you got to make an appointment 6 or 8 months out, what it means not to have access to any kind of rehab. Pain doctors won't prescribe medications because they're concerned about the FDA coming after them. I mean, it's tough out there. It's tough out there. Yeah, if you've got a gold-plated policy where you can go to any doctor you want, and the insurance company's not going to give you a hard time, you're going to have a whole different perspective on life than if you're on some HMO where you've got to go through 15 steps to get anybody to see you. And so, yeah, there are doctors out there who don't get it. There are judges out there who don't get it. I remember I had a conversation with my colleagues. I was, kind of expressing my frustration with a judge who was denying cases, that I thought he should be approving. And, my colleague said, well, this judge, he had a disc surgery. He had a herniated disc, and he underwent on a laminectomy or fusion, wherever he got. He goes, and he made a full recovery, but he was getting, physical therapy several days a week. He had, the doctor that works for the Falcons. He had the top medical care. He was able to rest at home. The work he does is non-physical. He could take off, he took off, 4 or 5 months. He has no idea what it's like when you're not in that situation. So, that's my point, is that it's not that judges lie or the doctors lie, is that they come out from they don't have any idea what the real world looks like. And so they come out from that perspective. And so, the first thing I said to you, Stephanie, was, it may be, and you look at the judge, it may be that you just have a really low percentage judge. You keep getting cases coming before that judge. And, what is the definition of insanity is doing the same thing over and over and expecting a different result. So you have to sort of change the parameters here. Ridiculous as this may be to say, you may have to move so you can get in front of a different judge. Now that you're in a different age category, that can make a difference. Are you still insured? So I think that, somebody can take another look at it. But yeah, when you've been denied a bunch of times, it's going to create a presumption that works against you. But so I don't think that it's that they lie. I think it's just that their philosophy or perspective is different. Shub. Okay, Shub 281. Okay. What did I call you? Shub? Yeah, actually, I went to a law school with a lady. Her last name was Shub. So there was actually a judge here, Judge Marvin Shub here in Atlanta. Passed away, but he was a very respected judge. So Shub, good to see you here. The truck, you're I think the truck driver you were saying. Luke Rogers, I'm doing a diary of symptoms. That is a good idea. Pain, insomnia, sleep. How many days should I have logged? Submit to my doctor. I will put my records. I'm sorry, look at the next comment, which I'll show you in a second. I think I would keep that, and, you could submit it to your doctor, or you could submit it to Social Security directly. I just think that just keep it indefinitely. I think, and what you might do down the road is, have a graph made of, so you can sort of see your pain level, on a graph format. You could, plug it into a spreadsheet, have somebody do that, or have an AI bot do it, and you can kind of see it graphically. So, but I just would keep it indefinitely. Okay, that's what I was laughing at. Is that ginger? No, this is sparkling water. I try not to drink sodas because it's just all sugar. It's just sparkling water. And I put what I do is I put a little lemon juice or lime juice in it, and it's I gave up soda probably 5 or 6 years ago. It was just liquid sugar, worst thing in the world for you. And so a friend of mine says you should get like sparkling water, put a little lime juice in it, and let me tell you, it's much more refreshing than soda. It's just that when you're doing a live stream, it gives you, makes you have to burp, which is not a good thing to do. But I like it, so I'm doing it anyway. Too much information, I know. Luis Alvarado, good evening. After receiving a denial from ALJ, what are my chances with the Appeals Council? Low, very, very low. The Appeals Council is a rubber stamp. Your chances are much better at the federal district court level. But you got to go through the AC level first. So go through the AC level, get it denied. And what I would do is find a district court attorney, and there are several of them out there, that have them look at it, and then even have them help you draft an AC appeal, because it's really the same thing you're going to be doing later on. Get that done, and that way you have your AC covered, and then when that's denied, you go to district court. Okay. Alicia says, can you talk about if there's a point in a person's calendar year that the judge would look at you, age 57, my half birthday is June, my hearing is in July. Well, I mean, again, being over 55 is more important than being 56 or 57. They will look at, if you're 56 and a half, that's not any different than 57. Now, where the issue has come into play before is what happens if you're, 54 years and 9 months or 10 months. Can a judge move you up and use a different category for the grid? And I believe they can. They can use what they call the grid framework to do that. But I don't think they can do it if it's more than maybe a month or two. So, if you're 54 and a half, they're not going to bump you up to 55. I know insurance companies do that. Once you hit the half year, they consider you the next year because they can charge more money is what they're doing it for. But in your situation, if you are 56 and you're going to be, 56 and a half, or 56 and 7 months at your hearing in July, you're going to be viewed as if you're 56 and a half months, not 57. So they don't bump you up to the next age category. If you were 54 and, in 10 months in June and your 55th birthday is in July, then they might move it up, but no more than a month, I believe. I could be completely off on that, but I think there's some rule someplace, but I seem to remember it's like a month that they can kind of fudge on. And DK is going back to, somebody talked about chronic fatigue as one of those invisible illnesses and said it could be hard. It very well could be. Chronic fatigue, there can be any number of reasons for it. Medication side effects, heart issues, certainly because your heart, low blood pressure, any number of things. And I think if you can get to the bottom of it and find an objective reason, that can be helpful. That's better than chronic fatigue. We don't know why, as opposed to chronic fatigue, a heart problem or a kidney problem or liver problem or whatever. It's better to have the specific reason in the record. Doug S. has chronic lymphedema, which is kind of a swelling in the legs, possibly heart respiratory issues. Haven't worked in years and trouble walking and driving, can expedite SSI disability. I'm barely getting by. You can ask for it. Again, it sounds like you're SSI only. You could argue dire need. Absolutely, you could. And let them know that, you are having a great deal of difficult time. You're about to be homeless. In fact, if you look up dire need in Social Security, it'll tell you what you've got to have. It's kind of toothless at this point because people will just, literally have to show proof you're about to be homeless or about to lose your car. But what I would do is I would reach out to your U.S. Senator and say, I need an expedited hearing because I'm financially destitute and this is my last resort. And, can you engage, create a congressional inquiry, and that'll move it along probably faster than a dire need letter. Zippy, I'm 60 years old with several neck problems, C4, 5, and 6. needing surgery. What are the chances of getting CDR? Not great. I don't think you're going to get one because, again, you are close to retirement, full retirement age. They're not going after somebody with, objective orthopedic problems who's 60. That's just not the people they're going after. DK was 56 when they approved. They looked at work history and a CDR. CDR means continuing disability review. That's when they review you for possible termination. Even one of the judges had to one Kansas City. Again, Stephanie, I know you've posted a number of questions here, and like I said, just to recap some of it is you've had multiple denials, especially multiple ALJ denials. That creates its own problem, its own momentum in the sense that, getting a ALJ to give you a different decision than the last 4 hearings you went to is going to be hard. The fact that you're 54 helps because maybe you're in a different age category. Maybe when you hit 55, it becomes even stronger. I still question whether you're insured after all this time. Maybe you are. And of course, it means you've been working, which, adds a different dynamic to the whole situation. But I kind of get the sense just from the way you're writing this, that you're seeing this as personal. Like I said, maybe you have a judge that's just a very low approval judge, but they're looking at the evidence. And the question I would really ask myself, or maybe have an attorney ask, look at it, what's missing here? Why are they denying you? You're assuming it's because they're lying and they're making misrepresentations. Is it possible that the evidence is not compelling enough? And, if you have an attorney look at it, who doesn't really have a dog in the fight, as it were, they may tell you there's not enough evidence here, or the evidence is not compelling enough. I know, I'll get these emails from people that, they want me to look at their medical record. They send me an MRI and it says, mildly bulging discs, no nerve root impingement, no stenosis, mild degenerative disc disease, or mild spondylosis, which is degenerative disc disease. They'll say, I got a case, don't I? Like, no, you don't. I mean, the medical evidence is not strong enough. And there's a lot of $10 words in that MRI report, but it's basically saying you have mild arthritis and you're not going to win with that, even at age 56 or 57 or 60. I think you have to open your mind to the question as to whether or not it's just medically not a strong case at this point. Is there what more you could do to make it stronger, as opposed to assuming that the judges are misrepresenting, or the doctors are lying, or the doctors that, it could be, all that could be true, but it also could be that the medical is weak. So I just throw that out there. DK says, look, I'm a disability attorney. I happen to believe that we add value because we sort of know what we're looking to do, and we have a vision for what this case is going to turn out to be. Do you absolutely have to have them? No. People have won cases without disability attorneys. In certain cases, if you're on a heart transplant list, you don't need a disability attorney. I mean, you're going to get approved. But most cases are not that severe. And I think that, and again, I'll give you an example. This gentleman I'm talking to tomorrow, real smart guy, and he'd been denied at recon, and he drafted up an appeal, not in the right form, but he did it in paper, which would work, about why he should be approved. And of course, the hearing request, that's not really the place for hearing to put that in a hearing request, but he did it. Well, what he wrote about was why he met all these listings. And, you could make that argument. And I wrote him back and I said, what we're going to talk about tomorrow is there's the grid rule argument, there's the functional capacity argument. Quite frankly, most listing level cases are caught early. I don't think that that's the most productive argument. I think that you have a much stronger argument to argue functional capacity because some of the medical issues there, or grid rule because some of the medical issues that limit him functionally. And I said the other thing you might want to look at is you might have to change your onset date to your 50 or 55. I can't remember which birthday. So, I mean, I'm just looking at it. I know it's, what judges want to do to approve cases. And so what I'm saying to this gentleman, and I would respond to DK is, when I'm looking at a file, I'm saying, okay, what is going to make the judge's life easier? What is it going to help? What can I do to help the judge want to approve this case? What can I give him or her? And, giving an argument that's defendable is going to be what's going to do it. And so, as an attorney, I kind of know what those arguments are. Not that they're brain surgery, but you do it enough times and you kind of know. When you're doing it on your own, it's very hard to kind of understand where the judges are coming from. Again, my hearing the other day, in fact, the woman who had just commented before, we changed the onset date by maybe a year, less than a year. And the judge in the middle of the hearing is like, because if you given consideration, we can save ourselves a lot of time, I think is what he said. If we can change the onset date to his 55th birthday, are you open to that? And I'd already talked to my client about it. Yeah, we're happy to do it. Okay, all right, we're done. Basically, okay, we just got to do a couple of things to firm this up, and we'll get, we'll get an approval out. So, again, I can talk shorthand to the judge because I know what he needed. I knew he was going to do that. And so I just based on the evidence that was there. So I expected it. My client was ready for it. And we got this case approved. So that's what an attorney can do for you. It's just understanding the rules of the game, the rules of the road. It's almost like if you're, if you're going out to play a sport, tennis, basketball, baseball, whatever, and you don't know the rules, you may be the most talented athlete. You may have the most raw talent. But if you don't know what the rules are, if you think there are 4 strikes in an at bat, okay, you're not going to win the game because you're going to be, missing out on what's needed. And so it's just stuff like that. So that's where an attorney really comes into play. Okay. George Graham. Yes, thank you very much, George. I appreciate it. Please do like and subscribe and click that button. Kay Couture, use your videos. Great. That's what they're out there for. That's awesome. That's awesome. Stephanie, I'm happy if you want to fill out the form. Happy to take a look at it, and we'll take a look. And again, like I said, and I don't want to go into your particular case in a public forum, but if you want to fill out the form, we'll be happy to take a look at it. Long-term care, yeah, I think that would work in your favor. I think that long-term care says that you don't have the capacity for activities of daily living. And I will tell you, the one big question I'm going to have is, do you have enough credits for SSDI at this point? And if you have the most recent prior unfavorable decision, I'd want to look at that as well. Can you win? Yes, you can win, Mary. Can you win an SSD case at recon? It happens, I wouldn't say frequently, but I'd probably say once or twice a month, I get cases approved at recon. It absolutely does happen. When I do a recon appeal, I'll put the argument in there. Sometimes it picks up steam and it's approved. So yeah, it's not frequent. It's percentage wise, 15% of cases taken at recon are approved, but some percent of them are. It does happen. Became full-time married with everything going on. Dodge might cut it until decided. Don't know what that means. Okay, Esoteric says, Lisa, I'm sorry what you're going through. This guy says, get a free case evaluation. Very, very good. Okay. This is, I've sent out, thank you. I appreciate that. Yeah. And we're all fine. It's just, how there's an old expression, when it rains, it pours. And it just seemed like a bunch of stuff sort of happened. And even something as silly as my garage door broke. So like the other day, my wife comes home and she had taken my car and she parks the car and I go to open the garage and it won't open and the spring had broken. So, I got this relative I got to take to the doctor. I got my grandbaby is sick. I got, I got 3 or 4 things going on. My, sister-in-law is out of town, so she can't help. And the garage door breaks. It's just, and then my son calls his air conditioning at his house. He has to get a new air conditioning for $10,000. So he comes over and he has taken his dog to the vet. The dog, to get his teeth cleaned, the dog was put under anesthetic. So he sleeps over at our house. So what happens in the middle of the night, the dog has bad stomach and poops all over the place in the room he's in. Just like one thing after the other. So it's just, sometimes you just got to laugh and just say, you know what, stuff like this is going to happen. And all you can do is just laugh. So, and it all, it gets better. But last week was a tough week. It was a tough week. So, but we're getting better. So everybody's on the mend. Finished my 4:45. I think it's the short form
in my first 3 years ago. I'm worried about the main things, losing and my school loans. Can you help me understand what to do? Again, I mean, you can't really do much proactive when it comes to the continuing reviews, other than just fill them out as you can. And the school loan, I know that the form asks you, have you been, does your disability case say 3 year or 7 year review? If it's a 7 year review, you can discharge student loans. A lot of times it doesn't say. I think you could just submit your approval notice and then ask for the student loan discharge. I believe is how that would work. But and sometimes you don't have all the information you need to do that, so you just have to keep giving them what you can give them. But if they don't tell you whether you're a 3 year or 7 year review, it's kind of hard to fill that out. So I don't know what you can do, whether you can call Social Security, good luck getting through, and ask them if you can find out whether you're a 7 year review, that you can get some documentation you can send to the student loan servicer to get that discharged, disability discharge. I don't know. Okay, appeals filed last week. Very good. Okay, Vince tells us it's 59 degrees, 70 tomorrow. Okay, you're starting to warm up, Vince. I don't know why you're in the Midwest, but here in Georgia, it's going to be 80 tomorrow, I think. Okay, I think we already talked about this. I like phone. I like phone. This guy says, please don't forget to like and subscribe. Absolutely. Eric says, thank you. You're welcome, Eric. Our CDs are about to become, possibly. I think there is certainly an argument that could happen, because I think that the current administration of Social Security is skeptical about, they don't want to pay out benefits. They want to preserve that trust fund. And the easiest way to get the fund more solvent is to cut people off. So I think younger people, those in their 30s and 40s, are going to be really seeing it more than everybody else. Okay, 56, chronic bladder public. Yeah, that's overactive bladder, rotator cuff. Yeah, I think that, that's a good case to me. Okay, your hairdresser, assuming you pay taxes, you've got the chronic pain, the bladder issues, surgeries, overactive bladder, rotator. I think you got a good case. I mean, I looked at the medical there, but if you were to fill out my form, you would be one I'm like, okay, this is somebody I want to talk to. I think that's a good case. Have severe neuropathy in both legs, EMG test, would that help? Yes, absolutely, because EMG is objective evidence of neuropathy. And if it shows it, that's going to really, really help you. Steve-O, once you're assigned a DDS rep, how long will be the next step? And step 3 for over a year, 59. We're seeing this more and more. It's taking 8, 9, 10, 12 months. You're at the point where I would tell you to contact your senator and ask for a congressional inquiry to get things moving. That's, a year is too long, in my opinion. Okay, RD, you stopped your hairdressing career after 5th surgery, or I'm not sure, 5th surgery, maybe it's 5th. Standing causes public pain, use restroom 3rd. Yeah, that's a winning argument right there, I think. Brenda says I have to pay Medicare Part B out of my disability check. I cannot. I don't know. I don't really deal with Medicare issues at all. I think that would be something. I mentioned Cal Hero before. He's the person I go to with my Medicare questions. Cal. Go to MedicareMall.com or info@MedicareMall and ask Cal. He could probably tell you. I can't. Mermaid Tales. I was approved for SSDI exactly 5 months, never stepped in a. Okay, you know what? It happens. Not typical, but it does happen. Roxana, I'll be applying for the second time with tremors, neuropathy, bipolar, schizoaffective, which tends to be approved without an attorney. 34. I think it's going to be an uphill battle, Roxanne, to be absolutely honest with you. 34 is really, really young. It's just very, very young. And bipolar is, unless it's really, really severe, tough. Tremors, are those going to be work preclusive? Neuropathy, how bad is it? I mean, but 34, that's the issue. It's going to be really, really hard. Rick has got a favorable decision. Onset May of 22. Okay. You're going to get a big 4. Okay. Took about 4.5 weeks. That's typical. That's awesome. Congratulations. Everybody, congratulations, Rick. Good for you. Excellent. Robert, my doctor confirmed the doctors were able to get them to send the records. Good. Very good. Very good. Very good. Good to see you, Robert. Thank you for taking on. Excellent. Nice hair. Natural. Yes, it is. I'm not, there are certain individuals out there who one might say have unnatural hair. This is all me. All cancers, no, not all cancers do. Usually it's got to be some metastasis or it's got to be something that is life limiting to get compassionate allowance consideration. Okay, chronic CHF, chronic asthma. What are your chances? How old are you? I mean, I think, these are all significant issues. I think your age is going to be a big point here. Jackie, yes, I can get you an, I think did I already do that? I may, if not, I'll send it to you. I'll download it and send it to you. DJS Gravely, just approved. Okay, excellent. Very good. Can you work part-time under SSD? Yes, but just keep it below SGA. No NOSCA. No, you know what? It was in Washington. I was thinking about going for a half second, and the issue is, it would have been fun to go to Washington. It was really fun last year. I got to meet a bunch of people. I talked on the phone at Reverend Meet. My sister-in-law was going or just got back from Portugal. And I know she was going to Portugal just with her. She and her husband went to Portugal. And so my wife and I watch our granddaughter, we were typically one day a week, and my sister-in-law watches her a couple of days a week at my house. My wife's husband, my daughter's husband watches it. His parents watch it one day. Point is, we were going to have to watch more because the sister-in-law was out of town. And then it turns out we had the medical issues going on with some family members. So, I was thinking about maybe kind of going last minute. Then when stuff started happening, I'm like, you know what? I just can't go. So I think there's one in San Diego later this year, which I'll look at. Otherwise, the one next year, this time of year, I very well might go to it. I just felt like I just had too much stuff going on. I had a lot of hearings, and I just said, you know what, this year I wasn't going to do it. But hopefully I can go next year. It was fun, and it was interesting to hear different perspective. Although I will tell you, and again I'll kind of, because I know we're getting long on time here. At NOSCA they spend a lot of time going over issues that are, I don't know how to put this diplomatically, where you're litigating over very tiny issues that, you're making legal points after you've been denied. I'd rather find good cases and win them early as opposed to winning on a esoteric issue on appeal. And so some of NOSCA is kind of focused on some of these very narrow issues. And it's good to know about those things, but end of the day, good cases are going to get approved. So, but it's great networking there, and you always pick up stuff, and I get the materials so I can read them, and I talk to people who've gone. So, yeah, it's worth going. I just couldn't do it this year. All right, Russell says, I think I'd referred you to somebody. No word. All right, let me follow up. I'm going to make a note, Russell. Let me follow up on that, and I'll get an answer for you on that. Okay. All right, I'm going to time for a couple more questions here. I'm going to go. All right, the appeals council is not going to, almost never is going to approve your case. You're going to just send it back to the ALJ to make a decision, and hopefully the ALJ will use your original onset date, which means you get a nice big check. But it's not the appeals council making that call. Not the appeals council making that call. Can I move out of the country? Yes. If you look up countries where you can go and still receive your SSDI, there's a Social Security pamphlet on that, and it will tell you where you can go where they'll send you money. Don't go to North Korea. Obviously, not going to send you money there. Don't go to Cuba. Not going to send you money there.
you go to Great Britain, you go to most places in Europe, you should be fine. But look that up. It's online where you can go. Okay, we are now at 2 hours. I'm gonna have to cut this off. So I appreciate everybody being here. I'm gonna really try to. I was hoping to I've been trying to get Gordon Gates on, and again, just our schedules have not really matched up. I'm going to try to get somebody on who was at NOSCAR, who just maybe can kind of fill us in on some of the stuff that went on this week there. Maybe we can do the next couple of weeks. And, I really appreciate the questions. Again, if you found this useful, please do give me a positive review on Google or Avo or whatever. You can go to jonathanginsberg.com and just review Jonathan there. But yeah, I really appreciate everybody's time. I hope everyone has a really great week, and we'll see you again next Wednesday. So for now, I'm going to go ahead and end this. Take care, everybody.